I want to thank all of you for being here today. Our panel, In the Crypto Legal Trenches, How Your Company May Be Affected. What we're trying to do is talk about the legal and regulatory issues that successful projects, successful companies in the crypto blockchain space are able to address and overcome and ship product. To be able to be a success. So often, legal and regulatory issues are a source of a source of limitation. They need to be navigated, but they can be navigated towards success and actually building successful products. My name is Timothy Spangler. I'm a partner at the law firm Deckard LLP. I've been in financial services for a couple of decades now. The last several years I've been fortunate enough to help lead our efforts around digital assets and blockchain. One of the interesting things about our practice here at Deckard is we represent both crypto native firms and traditional finance firms that are building in the blockchain space. So I think that gives us a very, very interesting perspective. One of the things I want to say is at the end of the presentation, when we have a few minutes left, there will be a mic. There's nothing like free legal advice. We are not your lawyers, though. So we'll open it up to Q&A if any of you have any questions that you want to ask. I'll let all of my fellow panelists introduce themselves, so let me hand it to Linda.
Hi everyone, I'm Linda Bartosh. I'm a partner at Deckard with Tim. I am a practicing capital markets attorney, helping lenders and borrowers, making loans of all types, issuing securities, buying and selling securities, and it's been really interesting as the space has matured to take, all of those lessons from traditional finance, regulated financial products, and try to apply them in this space and help companies that are coming up with creative ways to do business, new ways to do business, navigate those issues. The other thing that I particularly enjoy is helping to bridge between those two worlds, finding out what each might have to benefit from the other, from the knowledge of the other, from the ideas of the other, or the energy of the other, and help find ways for them to work together. Bobby?
Thanks, Linda. Yeah, I'm Bobby Radigan. I'm a counsel at Deckard. I focus on regulatory work, mainly with broker-dealers, asset managers, and funds. So we deal with it from the standpoint of once you realize that you are dealing with securities in some circumstances, what next, right? Do you have to register as an ATS if you're a marketplace? Are you offering securities? Do you have to register those securities? So we're kind of focused on what happens once you realize that regulation is happening. However awkward or clumsy it might be in this context, the ATSs, exchanges, whatever the new definition of exchange is, it's happening. So we keep an eye on that, and we like to help our clients navigate through those issues. Andrew?
So my name's Andrew. I'm a senior associate in Deckard's Financial Services Group. I've been working with crypto issuers and companies wanting to invest in crypto for 7 years now. So I got started on a Bitcoin ETF in late 2015, early 2016, when we had to write S1 disclosure before there was anywhere to copy and paste it from, as is the case with a lot of financial issuers. So I had to really learn about the technology in order to write the detailed risks, the disclosure, how everything works. And from there, I got so interested in this technology and really saw the potential for it. And from there, I kind of grew with the firm as we took on more matters to kind of consult on the technological issues, to follow all of the news, all the regulation development in all the areas, and try to kind of coordinate among our various attorneys on where it's going, what's going on, how do we address it from a legal issue and a technological perspective, which I think helps our clients very much to understand what they're doing, what they're building, and to not have them have to start from zero explaining to us in the way that we then in turn have to go explain to a regulator.
One of the things I think you'll see is there's not one set of legal issues that a crypto project, a blockchain project has to resolve. We have very different specializations overlapping, but very different. And I think what this shows is the complexity of the types of challenges that have to be overcome when you have a successful project. What I want to do before I turn it over to each of them to go in depth into their area of expertise is to really set some background, which I hope you find useful. Last year was a very eventful year. And last year raised a number of issues that our law firm, many other law firms, and our clients have been wrestling with. It was a tale of two different sets of headlines. One set of headlines got enormous amount of attention. The other set, even more important, much less. Starting with Do Kwon and Terra Luna, going all through the summer, firm after firm after firm, Celsius, BlockFi, Voyager, all the way through FTX. Again and again, we were seeing crypto firms failing and raising questions about whether they were being properly regulated. And really a significant pendulum swing, not just in the rhetoric on Capitol Hill, but also in doing transactions, doing projects, dealing with investors. What sort of attack surfaces were growing during the course of 2022 as we saw repeated failure after repeated failure after repeated failure. That's one set of headlines we all saw, read, and heard. The other, which I do believe when they write the history of 2022, when they write the history of blockchain, the first half of the chapter on 2022 will be the Ethereum merge. This is an amazing technology that is improving month on month, year on year. The Ethereum merge, arguably the third most important development in the history of blockchain if you give Bitcoin's launch number 1, Ethereum launch number 2, and then the merge, when it moved from proof of work to proof of stake. It shows how much upside the technology has. And it's so important when dealing with regulators, when negotiating contracts, when trying to understand the legal and regulatory attack surface of what you're building, the technology doesn't stand still. Good lawyers, good advisors to you and your project will be able to say the blockchain and the technology that you're building now and what you'll be using in 5+ years will be very, very different. I'm very fortunate. I've been able to meet with the SEC over the last 5 years 55 to 60 times, along with a number of us here on the panel. We have a very, very nuanced understanding, whether we agree with it or not, whether it's internally consistent or not. We have a very good knowledge as to what our regulators are thinking. What are the words that they're using to phrase the questions, to phrase the issues? I don't know, and I've never advocated saying there's no point in building anything until there's 100% clarity. I've been a lawyer for 29 years. There is absolute clarity in no aspect of the law, regardless of whether it involves crypto or not. It's understanding where do you like your risk. You leave home in the morning, you're accepting risk. What risk do you want? What risk can you price? What risk can you deal with? Based on that knowledge, you can have conversations with legal professionals like ours, and we can help craft solutions. That's really the career that we've chosen, to take complicated, decades-old statutes. Our financial markets in the US are governed by the Securities Act of 1933. I kid you not. It's been amended, but the overall structure of our financial markets is almost 90 years old. This disruptive technology has so much potential. Some of the most optimistic meetings I had with the SEC were in 2018 and 2019, talking about what this technology could do, blockchain technology, for market surveillance. It's powerful not only in its absolute capacity, but it's powerful to what can enable law enforcement, financial regulators, and others to be able to do their job more effectively. The last couple of years have been difficult, given the legal and regulatory environment, the increased number of enforcement actions and prosecutions. I appreciate that, we appreciate that, but I think they're very solid answers, very good ground to build your projects on. It's about involving lawyers early enough so we can help you ask the right questions, and if we ask the right questions, you're halfway through to getting the right answer. I know some of you have joined since we began. One of the things I want to say is, at the end of the presentation, we're going to try to keep 10 or 15 minutes. We'll have a mic. If people want to ask us questions, we're glad to answer them. I might be a lawyer, but I'm not your lawyer, so it's not formal legal advice, but we want to be here to help answer any questions that you have and be a resource for you. three different of my colleagues here with three different practices and three different perspectives on the types of crypto legal issues that are coming up. So let me turn it over to Linda to say a little bit about the issues and opportunities she's seen over the last year, and any insights you can share with the audience.
Yeah, so I think one of the things that's been interesting over the last year, and a question that I've gotten a lot in light of some of the headlines that Tim was just saying, our colleagues or clients being like, well, I guess that, crypto thing was a bust, right? We'll see, right? But I think it might come as a shock to most of the people in this room to know that up until this year, a large part of the financial markets conflated cryptocurrency and blockchain, right? In their minds, they're all the same thing. And I think in light of some of the pronouncements of the banking regulators this year, the FDIC said holding crypto is not consistent with safe and sound banking practices. You get a hit to your capital requirements due to the liquidity reserves. But they haven't had similar pronouncements on blockchain. And I think it's becoming clear to people in the financial services industry that blockchain really could be a key to changing the way that business is done in finance, whether it's the underpinning of how assets are serviced or monitored, if they are originated in the first place as native digital assets, if there's a way to convert them to digital assets. We've seen increasing interest in that space now that people are finally paying attention enough to understand that these are not the same things. We see that sometimes as looking for partnerships and licensing of technology. We see that to a lesser extent as people trying to develop their own in-house solutions. But I think that's been a really big development this year.
Your area is particularly looking at financing and financing structures, and so much of financing seems to me like a lot of aspects of the financial market really ripe for disruption. What are some of the most interesting applications that you've been able to work on and help clients with that really show the different areas of traditional financing that have the potential for this massive disruption and reconfiguration?
Yeah. So there have been a number of creative ideas that we've seen come from companies this year, and to bring it back to crypto a little bit, including from companies that are looking at novel ways to use crypto for real consumers in the real world. So for example, we've worked with people who are looking to provide financing that would be secured by crypto, but allow the proceeds to do other things with those proceeds, whether it's buy real estate or buy securities or just have a consumer loan for whatever consumer purposes. And that's novel because instead of selling your crypto in order to do all of these things or buy all of these things, right, you could always do these things. Now you're able to get a loan from a real financial institution. And that has implications for your future potential appreciation of the asset, for your tax consequences. And that's actually another thing that we've seen as a difference this year is, all day we've heard people talking about there aren't regulations, there's uncertainty of regulations. What regulations apply? A trend that we've seen in companies that are trying to kind of bridge into traditional finance is saying, okay, well, I don't know every regulation that applies to me, but I'm going to lean really hard into the ones that I know will apply to me or will apply to my customers. So we've seen an increase in attention to IRS regulations. We've also heard people favoring the name, you can choose your regulator. So if you want to be regulated as a security or as a different type of asset, you can design a program around sort of what that asset is going to look like to those regulators, and try to opt in to the regulator that you think will give you a best result. And who knows what regulators will say tomorrow or next week or next year, but I think regulators will appreciate that in the face of uncertainty, you're trying to do something, you're designing with intention, you're not looking to, pull one over on investors or on consumers, because, consumers are really the area where regulators will always be focused on making sure that, the big guy isn't taking advantage of the little guy. So that's been another big trend this year that we've seen, where companies, even despite all of the uncertainty, are trying to be mindful about what regulations exist and be mindful when designing their products in a way that works but is still creative and still bringing the benefits of sort of this next generation of financial products to the market.
What I've really appreciated over the last couple of years is a movement away from being intentionally agnostic or sticking your fingers in your ear and going la 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 when it comes to startups in this space, considering their legal and regulatory risk. There is a growing acceptance that although we can opt in to our regulator, we can optimize products and services for particular regulatory outcomes. The whole idea that you are subject to the law is not opt-in. And I think the best conversations we have with clients are clients who are mindful. What will be a huge driver of how your project is considered in 2025, 2026, is not just the decisions that you've made in 2023, but the way you document that thought process, the way you showed that you used reasonable care, that you engaged with the technology commercially available, that the decisions you made were not to move fast and break things, but you considered the state of the law with the clarity that it exists. You took steps that a reasonable person would in the management of their own affairs. You hired lawyers and advisors and compliance professionals, and then you built. I think that is the best way to approach this. Not willful ignorance, not I'll deal with it in a year, but making the best decisions and keeping records of why was that decision made in April 2023 about this aspect of the product. I have one final question, Linda, and then I'll move it over to Bobby. So many of the things that are on display here in this conference center are amazing. Brand new technologies, brand new ways of putting together finance, and we're involved in a good number of those projects, and it's really inspiring. But a lot of what we do is take this new technology and apply it to financial structures that have been around for decades. And I know, Linda, you have great expertise in the area of securitization. That's an area that I don't think many people walking up and down these aisles are thinking, oh, blockchain technology and residential mortgage securitization, what a natural pair. Can you speak for a minute on some of the revolutionary stuff you've been involved in that space?
Yeah, I mean, Tim's right. There has been, of companies who are doing that type of work, a real interest in moving to blockchain, whether it's residential mortgage lending, student loans, auto loans. There have been so many conversations about, let's change how we register these things or track them in order to make them, real digital assets. But one transaction that I do want to highlight from this year that was very novel and the perfect marriage of traditional financial structures and DeFi was actually a transaction that we worked on between Huntington Valley Bank and MakerDAO, the first partnership between a regulated financial institution and a decentralized autonomous organization. Like any bank, right, around the country, Huntington Valley Bank originates commercial mortgage loans to its customers. And as you know, MakerDAO has a stable coin. There has been a growing trend this year to have stable coins backed, not just by or not mostly by algorithms, but backed up by real assets. In fact, I was at a panel earlier today that actually was commenting on what a large percent of MakerDAO's revenue comes from its holdings of these traditional financial assets. But we actually came up with a structure where, Huntington Valley Bank is still the originator, has the lending licenses, has the know-how and procedures and relationships to originate these loans, but then it participates them to the MakerDAO community, which enables them to have an economic participation in these loans. It doesn't require them to, be constantly taking votes on things or making decisions. The bank remains the servicer, the bank remains the decision maker. It's just the economic participation of the benefits. And I think we're going to be seeing a lot more transactions like that It was a process to get the bank's regulators comfortable with the transaction. It was a process to figure out how are we going to do KYC. We have all these AML considerations and other things like that. They were not pushed by the wayside. There are real ways that you can address these kind of issues and get them done. And I think, it's exciting to see what kind of partnerships we see like that in the next year.
Fascinating, and absolutely at the cutting edge of how these two worlds are combining. I want to turn it over to Bobby. Bobby works at the absolute rubber meets the road intersection of markets and brokers and exchanges and dealing with the cornucopia of issues, not just with crypto as crypto, but intentional digital asset securities. It's a fascinating area. Maybe you can tell the audience a little bit about the things you've been working on and why you're excited about them.
Yeah, I should say I am excited. I'm also worried. The main reason is we have, a pronouncement, I would say, where the regulators say a lot of these things are securities. Great. Well, we have securities laws, like Tim said, Securities Act of 1933, the Exchange Act of 1934. And so those statutory regimes are supposed to govern how securities are offered, traded, sold, and they want to apply those regimes to digital asset securities. The issue is, it seems like, on some sense, the SEC and FINRA are not completely comfortable yet with broker-dealers custodying digital asset securities, forming markets that trade digital asset securities. And so the only model we have seen so far that works is the non-custodial ATS model, because every other broker-dealer cannot custody digital asset securities yet. So, we saw the SEC come out with their, the proposed, or not proposed, but their guidance for exemptive relief that would permit broker-dealers to custody digital asset securities. The only issue is they haven't approved any yet. We know there are a few, more than a few, that are in applications with FINRA to become FINRA members, but none have gotten approved. And so the issue that I worry about, which hopefully will be resolved in the next year or so, will be getting the SEC and FINRA comfortable with how digital asset securities are traded, settled, cleared, reconciled on the blockchain and distributed ledger technology. That's an issue that I think the rest of the world seems to be ahead of the US on. And so when we walk around, the vendors today, we see a lot of vendors that are doing great things, but they're not doing them in the US. So I worry if the regulators come around soon, the U.S. might miss out on what the rest of the world's already discovered.
When you look at those companies, you're going around seeing the products and services that they deliver. Very necessary in an ecosystem to have kind of market structure and to understand how that market structure operates. For people who are coming to this crypto first, who don't have the securities markets background that you do, what are some things about the Securities Exchange Act of 1934, the sequel to the Securities Act of 1933, and FINRA and the Division of Trading and Markets within the SEC? How can you educate the crowd on what's their traditional default approach and how that might differ from the expectations that all of us here with this white-hot technology might want? How do you reconcile the gap between what the SEC and FINRA are capable of dealing with given their historical baggage and all the great things that people in the audience here want to build?
Yeah, well, I think the key issue, and they've said this, is how does a broker-dealer have control over their customer assets and securities when that security is a digital asset security that's supposed to be trading on a decentralized market? And so we've seen a number of approaches over the past 2 years really, about explaining to SEC and FINRA staffs how digital asset securities really aren't just these things that are off in the ether, but no one has control over them. Yeah. And so we've seen, to Linda's point earlier, you're seeing a disconnect between what is a digital asset security versus the infrastructure behind it. And so the infrastructure behind it could be used for a lot of things. You think about transfer agents, custodians, basically instantaneous clearance and settlement. Those are all good things. The issue is getting the SEC comfortable with understanding that in some sense, there could be less risk by using those tools than what there is in the market today. And we've seen different models of products trying to get through the SEC and FINRA staff. You have ATSs that trade non-native digital assets, and you have other ATSs that are trying to create their own marketplace and create their own native tokens, right? So the native tokens, by default, the broker-dealer that runs that marketplace and owns the distributed ledger technology has control over those tokens. In those situations, the SEC should be able to say, yes, that's a good control location. And for those of you that maybe don't know what a good control location is, that's basically a concept that says the broker-dealer has total control over the disposition of their customer assets. So only that broker-dealer can control if that asset is bought or sold. And so once you get through, once we are able to convey the idea that control actually is present, I think you'll start to see a lot of possibilities open up.
I know people would love there to be a world, a United States regulatory regime, where you could have one solution and be able to trade countless different things, interact with countless different things on that platform. But can you walk through, just as a closing point, and then we'll hand it over to Andrew, digital assets, like pure cryptos, digital asset securities, proper securities that exist in traditional form. Can you explain a little bit about the different approaches that one entity, one platform would have to do to cope with those three different buckets?
Yeah, so in one sense, it's impossible right now.
Yeah.
Right, because hypothetically speaking, if FINRA did approve a special purpose broker-dealer, that entity can only engage in digital asset securities. It cannot engage in non-digital asset securities, traditional securities, or currencies. And so what you would have to do is, if you wanted to deal in all three, you'd have to have a broker-dealer that does traditional securities, a separate entity broker-dealer that does digital asset securities, a separate entity that's a money transmitter registered probably in all 50 states, or licensed in all 50 states, and also a money services business with FinCEN. So you'd have to have an organization that does all three of those things, and we've seen a few models of that. But it's really the digital asset security that's causing the issue right now. And before I pass over to Andrew, one thing we'll note is that broker-dealers and investment advisors, both, if you're dealing in securities and you're either affecting transactions or you're giving advice, whether that advice might be through algorithmic models or whatever, but if they're dealing with securities, no matter what you think the asset is, if the SEC comes in and says that's a security, you may have registration issues. So,
just to add on to that, it's unfortunate that we're seeing that from the SEC and from this commission, right? Past commissions have been willing to work with investors and industry to innovate. That's where we got Reg ATS from, right? It was temporary, individual relief that was eventually codified into an exemption for broker-dealers. And we're not seeing the friendliness here, and it's come to the point where the industry is starting to fight back, like as we've seen from Coinbase serving their mandamus earlier this week, just to get a decision from the SEC, right? We've had 55, 60 meetings in the last couple of years on the topic of digital assets, but it is difficult in a lot of cases to get a firm answer. There are things that we do that are firm and certain, and we've really moved the...
Sorry, they can't hear him?
What?
I can't hear you at all.
Oh, can you hear? Okay. And we have moved, our client's objective forwards in a number of ways. But there are other areas which Coinbase refers to where you just can't get an answer, right. And it's incredibly frustrating that we have to now rely on the courts to get this clarity that should come from a willing regulator wanting to move the industry forward, wanting to actually protect investors with workable rules, as opposed to standards, like their Exchange Act proposal that would bring in DeFi that's completely unworkable. So it's unfortunate we're seeing that, but if we have to go through it, go through litigation to bring about clarity, then it looks like it's gonna happen.
So if you could just repeat all that. I want to give Andrew the credit he well and truly deserves. Part of advising in this area is having a really deep understanding of the technology. So many people that we deal with, not just lawyers at other law firms, but counterparties, a whole variety of people. It's death by 10,000 analogies. This idea that, oh yeah, I know exactly what a Bitcoin is. I know exactly what a consensus protocol is. I know exactly what a wallet is. And it's kind of not always right, and you've always had a phenomenal deep knowledge of the technology. With that in mind, and taking the reservations that you voiced, looking at the projects that you've been working on, what excites you most about the power of this technology, not just in finance, but across the various use cases, to be very, very disruptive? What makes you most excited, and what are the kind of legal issues that you focus on with clients to make sure their projects are a success?
So on the what gets me excited, I like the idea of an open standard of rather than the multi-siloed approach that we see in traditional finance where everyone builds their own proprietary walled garden app. You have open source smart contracts like Aave, right, where we can see JP Morgan trading $500 billion in the last year of treasuries using Aave. They don't have to go in and build this new tooling. Assets can come in and transact on a universal platform where all the expediencies of blockchain, the increased settlement, transparency, etc. And so I think when we can get, of course, we're in a competition right now of all of the different L1s, L2s, side chains, L0s. To see where the market will converge. I think it's going towards Ethereum and the various L2s on there, but we're getting towards a standard. I think that's the goal, to allow this transacting without all of the individual walled gardens, without the black box FTXs of what's going on. Oh, just trust us. That's kind of the point of crypto, is to not have to trust an FTX. Which of course shocked all of us, shocked the industry. Even just noticing the tone here, it's much more somber than last year. I think we're all kind of still recovering from that shock and that lost belief that we had. But seeing everyone here, what excites me is that this is, I think, still CoinDesk's second largest consensus. People still came. It's still going. It's still moving forward. Right? I've seen the DAO hack live in real time in 2016. When everyone thought Ethereum was dead. And all of the regulation and all of the reports come out. But this industry moves in cycles, as we've seen. Everyone is still here, still building. Some of our large clients are here, still making announcements, moving forward, rolling out new products. And so I'm optimistic. Being aware of the time that we want to leave this for, open up for questions.
Yeah, absolutely. We have someone with a mic. No statements or stories, just questions. I want to get as many people in the round as possible. So anyone you pick. So up here in the front. Nice and loud.
Hey, I'm a third-tier law school graduate, and even I understand the Howey test.
Yes.
So what more does Gary Gensler need to know before he can decide whether Ethereum is a security? And as it is, Congress couldn't beat it out of him this week, and it just seems like he's doing it for political reasons. Thank you.
And it does seem that his sister agency, the CFTC, has a very clear view, if you read the Binance papers, what Ethereum is. These are questions that there should be answers to. We should have had them hopefully earlier. We still don't have them with sufficient clarity now. I appreciate the challenge that our regulators face, but answers are needed. And I think when we look at things like Ethereum, what we want to do is understand not only whether it is or is not a security, but more nuance around when did it become not a security. Go into detail about those processes. This is an incredibly important technology. I understand the need, the very important need, not to take a security and cut it up into 4 pieces and change the name and hide one of it behind another thing. That's legitimate concern. But clarity is something that we're going to have to continue to push towards. You think about Howey a lot, Andrew. What are your thoughts?
He knows.
He said so in 2018. He was teaching at Harvard.
I've seen the video.
He knows. I think it's a bargaining chip. Not speaking on behalf of Deckard, but yeah, I think it's political. I think it's a bargaining chip. But he's holding back. I think if he announces that Ethereum and is very clear on what aspects of Ethereum are or not or do not make it a security, as Bill Hinman did in 2018, then projects will start to come to him with checklists of, look, this is how we're exactly like Ethereum. This is how we're exactly like Ethereum. This is how we're exactly like Ethereum. He doesn't want to cede that ground as to, it's like Commissioner Hester Pierce says, it's regulation by ambiguity. The enforcement division has more in their bag when you don't know exactly what the rules of the road are, unfortunately.
My name is Dr. Badiga. I'm a medical doctor. I'm one of the founders of Quantum Technologies, which is a new blockchain and exchange. My question is, with the aggressive stance of the SEC, and we knowing that digital assets such as mortgage, housing, do you think there is, looking forward 5-10 years from now, that there is a possibility of our homes being labeled as a security?
You deal in the area of financing real estate. The question is, as more, and we see them around on the floor here, as more physical real world assets, hotels, houses, office buildings, as we find more and more of their ownership and financing moving to blockchain, is that going to take the Howey issues that Andrew and I were discussing before and be, I guess, a barrier on the adoption of this groundbreaking technology?
Plus, is there a hidden agenda or something?
Yeah.
Yeah. I mean, I could see it going either way. From my perspective, you know, a house will never be a security. A digital asset representing a house could be a security, but I would ask someone who thinks it should be a security, like, to what end? Would it need to be a security? I think that in general, when you have something that's just a representation of a real world asset, you know, we have a way to deal with the real world asset, and so something that is representative of a real world asset should be treated the same way as the real world asset, because otherwise you have an asset that you've now created like something incompatible with that. And if you want to make a true representation, you're not looking to make like a shadow asset that sticks out 20% past the real asset. Like, you just want the real asset. So for things that are just going to be representative of something that's not a true security, I don't think it would behoove anyone to.
How you set it up too,
Yeah.
right? So
Right.
if you have, like, for right now, if you own a house somewhere in the government, in the county, there's a book entry of who the record owner of that house is. That book entry is not a security. But what is a security today, if you take an LLC, have it hold real property, and then divvy up the LLC interest to multiple buyers, that LLC interest is probably a security,
Yeah.
right? So I think if you just take a step back and think about what you're doing, then you'll have a good idea of whether or not what you're creating could be a security.
The two product features that raise this issue again and again and again are fractionalization. Oh, we've got 1,000 people own a share of that house or that racehorse or that boat. And third-party managers. So you can own 1/1000th of this pedigree horse, and Bob will feed it, water it, enter it into races, and you will get 1/1000th of the proceeds of the horse. That raises securities issues. My car has a title, my house has a title. The fact that we're recording that on blockchain, as Bobby and Linda were saying, not in itself problematic, but that's usually not all that the startup wants to do. You had a question next.
Thank you.
Thank you.
I have a question about DAO governance tokens. We talked a little bit about this during the discussion, but specifically governance tokens that also have income participation rights in the efforts of the collective community.
Yeah.
Would those be considered necessarily securities that require registration? Could they be restructured as partnership interests? And what would be the right, maybe, legal wrapper to kind of obviate the need to be scrutinized by the SEC?
I mean, I've looked at a number of DAOs, and I appreciate what the DAO technology is capable of. But I think DAOs have been self-delusioned or misrepresenting what they're doing. I think to the extent, DAOs are not nearly as decentralized or autonomous in operation as they purport to be in the slide deck or at launch. And I think those things can be very problematic. As soon as you talk about revenue streams and the division of revenue streams, it becomes problematic. Because I think the SEC will look at that and say, well, that is an expectation of profit. Then I think what DAOs want is there to be this thought that, well, it's not efforts of others. We have 1,000 members and we are the membership, almost analogous to something like an investment club. We're not a fund or a bank when it comes to investing in securities. We're 100 people, we all have a vote. We're not subject to those regulations. But most of the DAOs I have seen have some delegation to a leadership committee, some delegation to an agent who are making the decisions in the real world. That, I think, creates a lot of attack surface that the people who are founding and operating DAOs don't necessarily spend enough time looking at. And we had a very unfortunate court decision about a month ago, one that I have been talking about the potential for this for a number of years. I don't want to be a corporation. You say that to me, Tim. I don't want to be a corporation, LLP. I don't want to be an entity. I don't want to have anything at all. A U.S. court recently said, well, fine, you guys are all, and girls, a general partnership.
There are worse things than a security.
There are worse things than security. If all of us are members of a general partnership, all 75 of us here, and a creditor has a bill for $10,000, being a general partnership means each one of us is on an undivided basis liable for the entirety of any debt our partnership has incurred. So she goes and signs a contract. We as a general partnership now owe the vendor $10,000. For some reason, her phone's not being answered. All of a sudden they go to your house and say, $10,000 you have to pay us. There are worse things than being a security. Just so we have room, one more question if anyone wants to throw their hand up. That gentleman over there, yeah, stand up. Just so she can see you. We're at 1:45.
So I saw recently New York State had alleged, I think against KuCoin, that they were selling securities, and they listed, I believe, UST and possibly another stable coin in there as well. What are your thoughts on that? Because I don't see the profit motive if you're buying a stable coin.
Andrew, do you want to comment on New York DFS?
Yeah, you know, DFS and KuCoin, they also added Ether. That was kind of an overreach. We've seen a lot of, there's clear fighting right now between the CFTC and the SEC on jurisdiction over stablecoins. In the Binance complaint by the CFTC, they explicitly included, I think, BUSD, but also USDT as commodities, and they explicitly spelled out that these are commodities. So we're seeing this direct conflict between the two regulators in charge of commodities and securities. We also have legislation now introduced to clearly put stablecoins within the jurisdiction of the Treasury, which was part of the president's paper put out in October. So, yeah, I'm not too concerned about if it goes to court on a resolution of whether a stablecoin is a security or not. At least if we're talking about an asset-backed one-for-one where they're treasuries, cash, etc. Algorithmic, more questionable depending on what the underlying is. But no, I'm not too concerned that dollar-backed stablecoins are securities.
Fantastic. Thank you all for spending the last 45 minutes. Once we get unmiked, we'll be here in the front of the room if any of you want to come up and ask us questions individually. Thank you so much for attending our seminar.